So I'll start off by introducing myself. So my name's Josie and I'm the employment law solicitor here at the Hunter Community Legal Centre. I'll start off by doing an acknowledgement of the country in which I'm presenting from today. So that I'm coming to you from the land of the Awabakal people, and I'll pay my respects to elders past, present and emerging, and also extend my welcome to any Aboriginal or Torres Strait Islander participants present today. So I'll just start off by offering a little disclaimer. So the information that I'm providing today is information only and shouldn't be relied upon as legal advice. If you do need any advice on your particular circumstances, then we recommend that you get legal advice about you as an individual, because the situation can always change. And also the information that I'm providing is current as of today. And I stress that because there are actually changes occurring at the moment. So, but it's recent, as recent as it needs to be for today's purposes, and only applies to Australian and New South Wales law only. So again, I'll stress, get legal advice if you have any specific legal issues. And then I also ask that you don't, because you will be provided a copy of this slide and this recording. I also ask that you don't share that around because it remains the property of the Hunter Community Legal Centre. So please don't distribute it in any way that we don't give you specific permission to do. So that's all the housekeeping out of the way. So I'll head straight into the presentation. And the first part is just to let you know a little bit about what our centre does. So just trying to figure out how to do the next slide. Oh, there we go, next slide. Okay, so the Hunter Community Legal Centre provides free telephone advice to people who live, work or study in the Hunter region. So we do a whole range of services and you can give us a call. So we have telephone intake days on a Monday, Wednesday and Friday. And you can give us a call, talk to one of our intake people, and they'll take down some of the information about your legal issue. And then that will get passed back to the solicitors who can give you a call back with some telephone advice. So we not only do advice on employment law, we also do things like credit and debt, AVOs, family law, traffic, fines, those sorts of things as well. So if you are needing any sort of legal assistance, you can give us a call and we can either assist or refer you to someone who can. Okay, so let's get into the employment side of things. So yeah, we've gone over that part already, so I'll just let you read that again, and we'll head into employment. So there's three types of employee, and I'll stress again, an employee is different from a contractor. So we'll be coming into that part in just a second. So when we talk about an employee, there's three different types. So a full-time employee works for at least 38 hours a week. Or is identified in some way, whether it be through an employment law contract, as a full-time employee. And they accrue things like leave, and they're supposed to work a certain set hours a week. And then a part-time employee, someone that works less than 38 hours a week, and they accrue leave according to how many hours a week they work. And then we've got a casual employee. So I'm going to talk about a casual employee as they're referred to in the Fair Work legislation now, but I want to stress that there is actually some changes occurring this week, which is not great for me in order to be able to give you up-to-date information. But at the moment, a casual employee is not defined in the Fair Work Act, but they're known as someone that works on an hourly, irregular basis. They're not entitled to leave. They can be terminated with no notice. Although you can usually be terminated with no notice, that can actually change if you have, for example, a certain clause in your employment contract that says otherwise. But generally speaking, not entitled to leave, and your hours are categorised as being irregular. But there is a change that's currently taking place with the Fair Work Act, and it's passed both houses of Parliament, but isn't actually law yet. That will actually add a definition to a casual worker in the Fair Work Act, and that that will essentially mean that yeah, there'll be some changes, and I think if you need to get some legal advice about what that might mean for you in your particular situation, stay up to date with the news and keep informed, and get some legal advice about your particular situation if you have any questions in relation to that. So when we talk about employees are often paid a wage. And at the moment, the minimum wage as of July 2020, and they often get updated each financial year, but from July 2020 for a full-time or part-time employee, the minimum wage is $19.84. And the minimum wage for a casual employee is $24.80. And this is different because a casual employee often gets what are called casual loading on top of their wage. And that's to make up for the fact that they don't accrue any sort of leave ordinarily. But this can obviously change depending on if you've worked that out with your employer. Your wage can be lower than this if you are a trainee or an apprentice, or if you're under the age of 21. So they are called junior rates. So they're usually a percentage according to how old you are. And they can also be higher, obviously. If you're able to be paid higher, that will be often set out in your award or your employment contract or your enterprise agreement, and can be negotiated based off your relationship with your employer. If you believe that you're being paid less than what you should be, then get legal advice, and you can speak to us about that if you have any issues around your wage. Okay, let's move on to the next one. So like I said earlier, so an employee is different to a contractor, and there are all sorts of different, I guess, variables that we take into consideration if we're trying to define someone as an employee versus whether or not they're a contractor. So on the list here, we've got, so level of control. So if you're an employee, your place of work usually exercises a lot of control over what you do, the work that you perform, how you do it, and that sort of thing. Whereas a independent contractor is able to have a little bit more control over how they're operating, and then that leads into hours of work as well. So an employee usually has set times of work, whereas a contractor can set their own hours as long as they're completing the job that they're contracted to do. Leave entitlement, so employees, if they're part-time or full-time, generally not casual, are entitled to leave. So we'll go into the different types of leave that you can be entitled to at a later point. But yeah, if you're an employee and a full-time or part-time employee, then you're generally entitled to some sort of leave. Whereas if you're a contractor, that's not the case. In terms of income and payments, so an employee, you'll get a wage or some sort of pay slip from your employer, and you'll get paid regularly, whether that be weekly, fortnightly, monthly, and that will come directly from your employer. Whereas if you're a contractor, you will be sending an invoice to the person that you're performing work for, and they will send you money according to how much you've calculated that they owe you for your work. In terms of tax and super, so if you're an employee, generally speaking, your employer will calculate the tax that you owe, and will pay your superannuation according to how much you've earned that week, and they'll calculate it all for you and deal with that side of things for you. Whereas if you're a contractor, you have to calculate tax that you're owed, so GST, that sort of thing. And you also have to set aside your own super and work out how much you want to put aside. In terms of levels of risk, so an employee, doesn't take on that much risk, because often it's the business that they're employed by that will take on that sort of liability, whereas a contractor is responsible for the risk that's involved in the work that they do. So if they make a mistake, it's on them as opposed to on their employer. Tools or equipment. So a employee will generally be given all of the tools or everything that they need to perform their job, whereas a contractor will usually need to provide their own equipment to be able to perform their work. So those are some key differences between the two. So it's always useful to be able to, before you start a job, categorize yourself and be aware of whether or not you're going to be an employee or a contractor, and always get clarity on your status. So we'll go to the next slide. I'll just grab some water. So when you're starting a job, we have a few tips for things that you need to be aware of and make note of, because often what we'll see, and particularly with students and younger people, the work, if you're performing work for someone, often you can be taken advantage of if in terms of being underpaid or not being paid correctly. And there are a few things that you can do at the start of a job to protect yourself and make sure that you're not going to be, well, you're putting yourself in the best position to be able to know what your rights are and know where you stand with your employer. And it's always best to know that before you go into a role, so that if anything goes wrong, you're completely aware of where you stand, so you can get proper legal advice and inform any lawyers that you talk to of your situation. So the reason I say that is because often the people that I talk to, they don't know what award they're covered by. They don't know if they have an employment contract, or they don't have a copy of their employment contract, things like that. So I'll go into it now. So personal details. So this is, find out who your point of contact is with the business that you're starting to work for. So make sure you've got a name, an email address, a phone number, someone that you're supposed to be conversing with about your employment, and someone that you can direct any questions to. So if it's a bigger employer, make sure you know who the HR person is, human resources manager is. Then you can, if you have any problems with your workplace, you know who you're supposed to address those issues with. Documentation. So things like, often your employer will want a copy of your passport or some sort of proof that you're able to work in the country. So whether that be a visa or evidence of permanent residency, you do not need to give a original to your employer. You can just give a copy, and that's fine. They do not need to request any original documents from you. Okay. All right, so you need to know your award or your enterprise agreement, or know if you're covered by one, and that's a really big one that most people that I speak to cannot answer, and that's not anyone's fault. Often employers just don't see it as something that people need to know, or they just go past it very quickly in the introduction stages of when you're starting a new job, but it's actually a really important thing to know. So there's all sorts of different modern awards, and they cover every industry. So things like retail, hospitality, and basically everything under the sun. So it's really important to know your award or your enterprise agreement. And if you don't know, the Fair Work Ombudsman is actually a really good service to utilise, because you can call them up and you can tell them, this is what my role is, this is who I work for, this is what the sort of things that I do in my role, and they can tell you, okay, yeah, we think you're covered by this award and you should be paid at this rate. So they can give you all that information. So under your award, the other real big reason to know what award you're covered by is that every award is different. So every entitlement that you have can be different according to which award you're covered by. And so that's why employment law is such a tricky area, and it's you do need to get proper legal advice, because you can have one award say that you're entitled to breaks at certain times of the day, and then other awards won't cover that. So it always depends on what award says what. So that's why it's always important to know that. In terms of pay, make sure you know how often you're going to be paid, where that money is going to go to, how are they going to pay it to you, are they going to transfer it to you, are they going to pay you in cash, and are they going to be providing you with pay slips? And that's a big thing. And I think that's at the bottom there, but I'm going to talk about it now, because pay slips are another big thing, is that a lot of employers don't provide them, even though they are supposed to by law. So if you're not receiving any pay slips, especially when you're starting out, to say, oh, by the way, haven't received any pay slips, and make sure you have all these conversations in writing. So maybe send someone an email and say, hi, I haven't received my pay slip. Can I please be sent that so I know how much I've earned this week, or something along those lines, because there should always be a record of how much you're earning and how they're calculating your pay. Contracts. So employment contracts are always important things to have as well. So that will include things like what your status is. So it will confirm, are you a full-time, part-time, casual employee? It will confirm things like, when you can take breaks, or it can have anything and everything in it, and it can really form the basis of your working relationship with your employer. Not everyone has an employment contract, and not everyone is given one. And if that ever happens to you, it's often a good idea to put an email in writing to your employer and just confirm with them, this is my understanding of our relationship, that I'm going to be a casual employee, I'm going to be working these hours, I'm going to be paid at this rate, this is my nominated super fund where my superannuation is going to go, and just say, can you confirm that? And then that way you have in writing that someone has confirmed that these are all the things that you're going to have in your employment relationships. You at least have something in writing to fall back on if anything goes awry. So it will also, your employment contract might also state things like whether or not you're entitled to any notice if your employment terminates. It might say if you're entitled to any leave, if you have any restraints on your employment after you leave. So things like you can't work in this industry for a certain period of time, or you can't work within a certain radius of the business for a certain period of time. So those are often common things that are in an employment contract. Also, if you're going to be on a probation period for a certain amount of time, that's also important as well. Okay, let me just double check. Okay. And sometimes the contract says that you need to have a right to work in Australia. So sometimes this can mean having the right visa or permanent residency. And often your employer will want some sort of evidence of that. And again, you don't have to give them any original documents, but just provide them with a copy to confirm that with them. Okay, just check the next slide. Okay, so yeah, so we're going into employment contracts a bit further as well. So yeah, so make sure that you're, if you don't have an employment contract, that you're sending an email, putting something in writing to your employer, either asking them to confirm these things with you, or you put it to them and say, what is my position? Am I full-time, part-time, casual? What is my rate of pay? How much am I getting paid? Yeah, what type of employment? Do I get any leave? I'm here on X visa, for this period of time, that sort of thing. So a sham contract, which we've got at the bottom there, is another issue that you might need to be aware of. So some employers will try to make your employment relationship look like a contractor relationship when it actually isn't. So often this will mean that employees are trying to prevent themselves from having to pay out leave or pay out the entitlements that you would otherwise be entitled to as an employee. But you are, for all intents and purposes, an employee, you know, and again, I'll call back to that slide that we looked at earlier. You know, if you're being given all of your tools, if you have, you know, not much control over the hours that you work or the type of work that you do, yet you're still being called a contractor and you're still being made to do invoices, then you might be in what's called a sham contract. And it's really important to get legal advice if you think that that's the case, because every single situation like this turns on the individual facts of the case. So you'd really need to get some independent legal advice about that and talk to someone. And there are serious financial penalties that apply to employers that sham contract with people and make out that someone's a contractor when they're actually an employee. Okay, we'll go to the next slide and I'll grab another drink of water. And again, if anyone's got any questions, just pop them in the chat and I can address them. Okay, so we're going to be talking about leave. So we've got all sorts of types of leave under the Fair Work Act. And these will mostly apply to people that are full-time or part-time, but not necessarily. So I'll start off. So annual leave, if you're a full-time employer, generally speaking, you're entitled to 4 weeks of annual leave a year. Obviously, this can be more if that's in your employment contract, but it cannot be less if you're full-time. You are entitled to a minimum of 4 weeks annual leave. If you're a part-time employee, then you accrue annual leave according to how many hours of work you're doing a week, and then it accrues that way. So say if you work half the amount of time that a full-time employer would be working, then you're entitled to half the amount of annual leave. Personal or carers leave, also called sick leave, is something that people are entitled to take, if they're sick or if they're caring for a family member. So you're entitled to 10 days a year. So if you're full-time, and again, you can accrue it as well, but generally speaking, everyone's entitled to, well, full-time and part-time employees are entitled to 10 days a year. And if you're casual, you're not entitled to either, unfortunately, but that's why you get paid extra or casual loading per hour if you're casual, and that's to offset the fact that you're not getting annual leave or personal leave. Parental leave is slightly different. So if you've worked for an employer for at least 12 months for a continuous period of time, you can take 12 months of unpaid parental leave, and this applies to full-time and part-time employees. Casuals, there can be some exceptions, and you can negotiate that with your employer and get legal advice about that. So you can take parental leave if you're giving birth yourself, if your partner is giving birth, or if you're adopting a child under the age of 16. So you're entitled to return to work immediately after you've finished taking unpaid parental leave, either to the job you had before you went on leave, or if that job isn't available, then to a similar suitable position. And there's also a paid parental leave scheme, and this is available, like this sort of information on that is available on the Department of Human Services website, and that again depends on your status as an employee and how long you've worked for your employer and that sort of thing. Part-time employees are, again, their leave entitlements are reduced based on the days that they work. And if you're a casual, generally speaking, you're not entitled to annual leave, personal leave, or parental leave, but you are entitled to 12 months of unpaid parental leave if you've been employed by your employer for 12 continuous months. So pandemic leave, and this is something that is potentially going to be taken out quite soon, but obviously during the 2020 was part of the types of leave that people could have available. So you need to have met certain eligibility requirements to be able to apply. and it's regulated by the New South Wales state government, so slightly different to the other types of leave, which are all federal. So you would be eligible if the New South Wales government or New South Wales Health had directed you to self-isolate because either you, someone, or you've been in contact with someone with coronavirus, or a child under 16 who has coronavirus or has been in contact with coronavirus is someone that you care for, or if you're caring for someone else that has had coronavirus or has been in contact with someone who's had it. So in order to have been eligible for the pandemic leave, so yes, you needed to have been directed to self-isolate, you need to be at least 17, living in New South Wales, being an Australian resident, or have a visa that allows you to work in Australia. You needed to have been unable to go to work or earn an income and have no other leave entitlements. Yeah, so if you're a member of a couple, then you could both claim separate leave if you both needed to self-isolate, but you'd have to complete separate forms in order to do that. So I would just check the news to see when that's still going to be in place, for how long it's going to be in place for, because obviously it might not be needed in the coming months. Fingers crossed. Okay, so next we're going to be talking about JobKeeper. And again, this is a part of the law that's changing. So we can not go too much into it today, because it's going to be, well, so far we've been told it's going to be ending on the 28th of March. So that's the end of this month. But originally JobKeeper was something that came in so that the government would subsidise the wages of workers where a business had experienced a certain percentage of downturn because of coronavirus. So people who had been stood down or had their hours reduced would still be able to be paid a certain wage during that time to supplement their income, and that wage would be supplemented by the government on top of whatever their employer was paying them. So for a certain period of time, that rate was about $1,500 a fortnight, but then that's subsequently been reduced as each of these extensions have come into place. So there was an extension from the 28th of September to the 3rd of January, and then a subsequent extension after that. And then recently the government has confirmed that the JobKeeper scheme will end at the end of this month, but who knows really? Until it's in writing, we just don't know. So yeah, so that's JobKeeper. If anyone's got any issues around JobKeeper, again, get legal advice, because we often saw a few cases of people that had either incorrectly been paid JobKeeper or hadn't been paid JobKeeper when they think they might have been. But what I will say to that though is if your employer hadn't signed up for JobKeeper and you thought that you might have been eligible, you can ask them why, but you couldn't actually at the time force your employer to sign you up for JobKeeper if they didn't want to. So there might not be too much that you can do, but always get legal advice and just clarify your individual situation if you have any issues in relation to that. Okay, so as part of COVID-19, we also saw obviously some salary cuts and things like that. So if your employer had told you that they couldn't afford to pay you your usual wage, you didn't actually have to agree to this. So your relationship with your employer is a relationship that you've both agreed to. So you can't actually, or your employer can't actually change core parts of your employment, like your wage, without telling you about it and without you agreeing to it. So it needs to be discussed, and you cannot be forced to accept it. You could agree to a pay cut if the only option was that you're going to lose your job entirely. So check your minimum rate of pay under your award or enterprise agreement, and the pay cut cannot be less than the specified minimum wage under those award or enterprise instruments. And the pay cut, cannot be less than those specified amounts. So negotiate whether your working hours are also going to be reduced if your pay is going to be reduced, and check whether there will be a revision of your job requirements. So if you're going to be paid less, are you going to be expected to do less in your job as well? And keep, if if your performance indicators are going to be reevaluated, or your targets, could you be able to work more flexibly to make up for the fact that your salary is going to be cut? So those are all things that you can negotiate with your employer. Redundancy. So redundancy is a type of termination of employment due to your job no longer being required to be performed by anyone. So it's not related to your job performance as an employee. It's mostly related to, a business restructuring or experiencing a downturn so that they don't need your job to be performed at all. So many businesses made people redundant during the pandemic. And it's important to know your job status, your entitlements and your rights if your position is being made redundant. So under the Fair Work Act, a full-time or a part-time employee who has worked for more than 6 months in a large business, so that's a business with more than 15 employees, or more than 12 months in a small business with less than 15 employees, has the right to receive notice and redundancy pay if their position is made redundant. So the period of notice and the pay is dependent on how long the employee has worked for the employer, and whether that period has been continuous. So the longer you've worked there, the more money you're entitled to, and the longer the period of notice that you're entitled to. And that payment, that notice period can be paid in lieu of actually being given notice, or you can just serve out a notice period. Your employer must consult with you about any proposed changes as outlined in your award or enterprise agreement, or your employment contract as well. So that's why it's always important to be checking these instruments and knowing what you're covered by. And your employer has an obligation to consider whether there are any other areas that you could be redeployed in the business. And if you've been made redundant or have any questions about redundancy, then get legal advice, because it can be quite a tricky area. And lastly, we've got stand down provisions. So, and this was also something that was very common during the pandemic, was that people were being stood down because businesses were being shut down, couldn't open, that sort of thing. So it still means that you have a job. So you shouldn't resign or be asked to resign during a stand down period. You don't work, but generally you still accrue leave entitlements if you're a part-time or full-time employee. So even though you're not working and you're generally not receiving a wage because you're not working, you're still accruing that leave. So that's why, a lot of people were confused about their status while they were being stood down. So it's if that ever happens to you, then it's always important to seek clarity from your employer or get independent legal advice about that. So when you're stood down, it's because you cannot do any useful work for your employer, because there's been a stoppage. And the important thing to keep in mind here is that the stoppage needs to be for a reason that is not your employer's fault. So the pandemic is an example of that, because it was something outside of your employer's control, and that's why they were unable to continue providing work for you, whether it was because the government ordered them to shut down or something along those lines. But it has to be for a reason. You can't just be stood down because your employer doesn't want to pay you that week, or something along those lines. There needs to be a reasonable stoppage, and that needs to not be your employer's fault. So not everyone in a workplace needs to be stood down. So there may be some work to do, but not enough for everyone. And when an employer makes a decision about who gets stood down and who gets to continue working, it's important that these decisions are not made on a discriminatory basis. So when we talk about discrimination, we talk about people's protected attributes, which are things like your nationality, your race, your religion, sex, if you have a physical or mental disability, or family responsibilities or something along those lines. So if they're making the decision to stand some employees down and not others, they need to be considering all those things and not be discriminating people on those grounds. So when you are stood down, it still means you have a job, so that when work picks up, you can return to work. If you're offered other work in the meantime from a separate employer, you may be able to work with that employer, but you'd need permission from your original employer before you do that. You will still accrue leave if you're a part-time or full-time employee while you're being stood down. And even if you are stood down, you can still ask for leave and take out leave. And you cannot be stood down while you are on leave as well. So that's a confusing aspect. But yeah, while you're on leave, you're considered working, if that makes sense. Okay, so the law says that you do not need to be paid while you're being stood down, but your employment contract, award, or enterprise agreement might say something different. So it's important to check these as well. So if you think that your employer hasn't followed the rules, then get some legal advice. If you are stood down and get the direction, then get the direction in writing, get dates, get clarification on when the stand down is going to begin. See if you can get some idea of when they think that that's going to end. Obviously, that's not always possible. Get clarity over whether you're going to be paid during that time or whether you're going to be able to take leave. Make sure they're confirming to you that you are still accruing leave, and get in writing permission to work in another job if you do find alternate employment during that time, and make sure you get all of that in writing, obviously, so that you have some evidence if any situations arise where they try to say, no, we never told you that you could work for someone else, and that sort of thing. So if they aren't able to provide that to you in writing, write an email yourself and get them to confirm it. So if you're, you should also contact Centrelink as well if you're ever stood down, and see if there's any entitlements that you could be getting while you're being stood down, and see what you're eligible to. So often it could be something like JobKeeper or something along those lines. Okay, so the next slide we're looking at, just grab another drink of water. Okay, so discrimination can be quite a tricky area, and it can be a bit complicated, but I'll try to keep it simple. All workers in Australia are protected from discrimination in the workplace. So discrimination happens when your employer takes action against you because of your particular characteristics. So like I said, these are called protected attributes, and they include things like race, ethnicity, sex, intersex status, gender, sexual orientation, family responsibilities, if you're breastfeeding, if you've got carer responsibilities, your religion, your political opinion, all of these things are, and disability as well, are all things that are covered under law, and they're classified as protected attributes that your employer cannot act against you because of. So the types of action that can be taken against you by your employer is known as an adverse action. So that's what we refer to it. So this includes things like terminating your employment, refusing to employ you in the first place, injuring you either physically or financially, or treating you worse off than your co-workers. So those are all different types of action that your employer can take against you that would potentially be grounds for a discrimination case. So there are two different types of discrimination. So we've got direct discrimination and we've got indirect discrimination. So direct discrimination is where you are directly discriminated against. For example, you tell your employer that you're pregnant and they say to you, we're not hiring you because you're pregnant. So that's it. That's the employer saying to you, because of this attribute that you have, we are not going to hire you. We're going to take this action against you because of that particular characteristic that you have. On the other hand, indirect discrimination can be a little bit more difficult to identify and a little bit more complicated, but it's essentially where your employer or potential employer has or introduces a requirement or rule that seems to apply to everybody, but actually serves to disadvantage someone because of their protected attribute. So a good example of this would be if your boss decides to schedule an important weekly meeting on 8:30 on a Tuesday, which is an hour before you usually start, and you have a family responsibility at that time, and you've notified your employer about it, you've spoken about it, and they refuse to move the meeting. And because of that, you're disadvantaged in your role in that workplace. That's an example of indirect discrimination because they're not telling you that specifically that's why they're doing it, but it goes that because you have that protected attribute, you're being negatively affected and disadvantaged compared to your co-workers. So if you ever feel like you're being discriminated in the workplace, you can get legal advice from services like ourselves, or you can go to the Fair Work Commission, or the Australian Human Rights Commission, or the Anti-Discrimination Board. So there's all sorts of different services that deal with this side of things, and there's lots of information out there as well. And on the next slide, I'm going to be telling you about all the different services that you can access if you have any sort of employment or discrimination issues that you would, if you ever needed advice. So I'll talk you through them because these are really important ones to know. So obviously our centre, so if you live, work or study in Hunter, then you would fall into our catchment area, so you can give us a call. But if you're coming to us from the Aroomba campus, then the Central Coast Community Legal Centre can potentially provide you with advice. And there's also the Mid-North Coast Community Legal Centre if you're in the Port Macquarie area. And there's several community legal centres in Sydney. So you can go on the national CLC website that will, you can put in your postcode and you can find out which CLC you can call if you live somewhere else. And then the other one that I really want to point out to you is the if you're a migrant worker and you're having any issues in the workplace, and they're particularly tied to your status as a migrant worker, or if you have any issues with employment and your visa, the Migrant Employment Law Service is run by 4 legal centres in Sydney, but it's a statewide service. And they provide specialised advice on migrant employment law. So they're a really good contact to have if you have any issues around that. Otherwise, there's the other statewide services. So the Fair Work Commission. So if you are ever unfairly dismissed or have any sort of action that you would need to bring, then the Fair Work Commission is where that would occur first. And then the Fair Work Ombudsman is you can basically use them as a telephone service. So if you aren't sure what your wage is or you want to know what award you're covered by, they're a really good first port of call if you've got any employment law issues. And then if you've ever been discriminated against, the Anti-Discrimination Board, which operates at a New South Wales state level. And then there's the Australian Human Rights Commission, which works at the federal level, but you can approach either and they can tell you about eligibility and that sort of thing as well. So yeah, that's the presentation. All right, thanks so much for attending.
Anyone has any questions, you can direct them to us after this session as well. You can follow us on social media and get in touch with us as well. If not, then we can end the session here.